Hello everyone, this is the third part of the Indian Polity revision series, and it's a swift revision, and today we are going to start with the Prime Minister topic, and the rest of the topics will be followed. So without wasting much time, so let us jump into the concepts. So the first one is Prime Minister. Okay, let us try to understand about Prime Minister. So these are the important articles which are actually connected with the Prime Minister. You can see that Article 74 of the Indian Constitution talks about Council of Ministers to aid and advise President. So there is a mention about Prime Minister. Article 75 deals with other provisions as to ministers. Then 77 talks about conduct of business to the Government of India. Then 78 talks about duties of Prime Minister as respects the furnishing of information to President. And 88 talks about the rights of ministers and Attorney General as respects houses. Okay, so these are the important articles which are actually connected with the position Prime Minister. Now regarding Chief Minister, what we need to understand is Article 163 of the Indian Constitution talks about Council of Ministers to aid and advise Governor. Article 164 talks about other provisions as to ministers. Article 166 talks about conduct of business to the government of a state. Then Article 167 talks about duties of Chief Minister as respects the furnishing of information to Governor. And 177 talks about rights of ministers and Advocate General as respects the houses. So here the major difference is almost the functions are same, but the names is different. On the one hand, we are actually using President, and on the other hand, you can see that we are using Governor, the government of the state, and also the Advocate General. Okay, so other functions are similar. Okay, functions are very similar to the Prime Minister. Now, Prime Minister. Prime Minister is the head of the government. Okay, and Chief Minister is the head of the government. So here, Prime Minister is the head of the Union government, Chief Minister is the head of the state government, and Prime Minister is the real executive authority, and CM is also the real executive authority. So what do you mean by this real executive authority? That is de facto executive. Okay, basically there is de facto executive and de jure executive, and de facto executive holds the real power. They take the decisions. Okay, so Prime Minister with the Council of Ministers are actually taking the real decisions for the government, and on the other hand, in the states, the Chief Minister plus the Council of Ministers are actually taking the decisions for the state activities and the state administration. So that is why it is called as the de facto executive. And why it is actually de facto executive? Because we are living in a democratic state, and in the democratic state, people are having more power, and people have actually elected these representatives, and they have actually appointed these head of the government. So that we need to understand that whoever is elected directly by the people will have more power. So in the case of presidential election is indirect in nature, but in the case of Prime Minister, it is more direct in nature. That means more participation of people are there in the election of the Prime Minister and Council of Ministers. That is the reason why it is the de facto executive in the country. Now, the election and appointment. So, Prime Minister is considered to be the leader of the majority party in the Lok Sabha. Okay, in the Lok Sabha, Prime Minister is considered to be the leader of the majority party, and the Chief Minister is considered to be the leader of majority party in the State Legislative Assembly. And Prime Minister is the leader of the largest party or coalition, and same applicable to the Chief Minister also in the state level. And eligibility, a citizen of India, a member of either Rajya Sabha or Lok Sabha. So, now what we need to understand is the eligibility criteria for becoming a Rajya Sabha member and eligibility criteria for becoming a Lok Sabha member, you need to understand. Now, Chief Minister, same thing, a citizen of India and member of the state legislature. Okay, a member of the state legislature. Now, oath. So, what is the oath given to Prime Minister and Chief Minister? To bear faith and allegiance to the Constitution of India, to uphold the sovereignty and integrity of India, to faithfully and conscientiously discharge the duties of his office, to do so right to all manner of people in accordance with the Constitution and the law, without fear or favor and affection or ill will. And the same applies to the Chief Minister also. The same kind of oath is applying to the Chief Minister also. Okay. Now coming to the functions, and regarding Prime Minister, he recommends the President on who to be appointed as the ministers. And in the case of Chief Minister recommends the Governor on who to be appointed as the ministers. Then the Prime Minister designates or reshuffles the portfolios of the ministers, and same applies to the Chief Minister also in the state. And Prime Minister can ask a minister to resign. Chief Minister can also ask a minister to resign. And the meeting of the Council of Ministers is headed by the Prime Minister, And in the state, the meeting of the Council of Ministers is headed by the Chief Minister. All activities of the ministers are guided and controlled by the Prime Minister in the Union, and the same applies to the Chief Minister in the state level. And if the Prime Minister resigns, the entire Council of Ministers collapses. And the same applies to the state also in the case of Chief Minister. Okay, functions. All the activities, decisions that are taken up by the Council of Ministers are communicated to the President by the Prime Minister. So, Prime Minister act as a bridge between the Council of Ministers and the President. And same applies to the Chief Minister in the case of Council of Ministers and Governor in the state. And to report to the President information about the administrative affairs if and when asked by the President. So that is the duty of the Prime Minister to submit that. And same applies to the Chief Minister in the case of submitting the details and information to the Governor. And if any minister has decided on any issue, the same has to be reported to the President by the Prime Minister when the same has not been considered by the Council. So if the Council is not considering some decision and the Minister himself is actually taking that decision forward, and that particular decision need to be communicated to the President by the Prime Minister. Okay, the same applies to the Chief Minister in the state level also. And the Prime Minister gives his advice to the Governor for the appointment of the following persons. One, Attorney General of India, then Chairman and members of the Union Public Service Commission, the Election Commission, etc. So many other important positions are actually appointed based on the advice given by the Prime Minister and the Council of Ministers. And here in the state, you can see that Advocate General, Chairman of the State Public Service Commission, State Election Commission, etc. are actually advised by the Prime Minister to the President for the to the Governor for the appointment. Then Prime Minister advises the President with regard to summoning and proroguing of the sessions of the Parliament, and the same applies to the Governor in the case of summoning and proroguing the sessions of the state legislature. Then the Prime Minister recommend dissolution of Lok Sabha to the President, and Chief Minister recommend dissolution of Legislative Assembly to the Governor, and the Prime Minister announces government policies on the floor of the House, and Chief Minister announces the government policies on the floor of the House, the state legislature. Then the Prime Minister is also acting as the Chairman of the Cabinet, the Chairman of the Cabinet. So the Prime Minister is the Chairman of the Cabinet and presides the meetings of the Cabinet. He can impose his decision if there is a crucial opinion difference among the members. So he's the Chairman of the Cabinet. An official representative of the country, the Prime Minister represents the country for high-level international visits or meetings, and the link between the President and the Cabinet. So already we mentioned that. And head, the Prime Minister is the head of Nuclear Command Authority. Niti Aayog appoints the committee of the Cabinet. Then the Department of Atomic Energy, Department of Space and Ministry of Personnel, Public Grievances and Pensions. And Prime Minister is the Chief Advisor, and he acts as the Chief Advisor to the President. So these are some of the additional functions of the Prime Minister. So these are some of the important aspects related to Prime Minister and the Chief Minister. Okay, almost their functions and their duties are almost the same. The only thing is where they are applying this power, that is the only difference. So one at the union level and one at the state level. The Council of Ministers. So very important to understand that. So Prime Minister along with the Council of Ministers is considered to be the de facto power in our country, and in the state, Chief Minister along with the Council of Ministers. So let's see the details about Council of Ministers. Union Council of Ministers. And these are some of the important articles which are connected with Union Council of Ministers. Article 74, a Council of Ministers to aid and advise the President. Then other provisions as to ministers and conduct of business of the Government of India. Duties of Prime Minister as respects the furnishing of information to the President, and rights of ministers and Attorney General as respects House. So 74 to 88, you can actually see that these are some of the articles which are dealing with the Council of Ministers. And coming to the State Council of Ministers, you can see that Article 163, Council of Ministers to aid and advise the Governor. Then 164, other provisions as to ministers, and 166, conduct of business of the government of the state and the duties of Chief Minister as respects furnishing information to the Governor, and rights of ministers and Advocate General as respects the House. So what you need to understand is one thing is actually connected with the Union Executive and another thing is really connected with the State Executive. Now, what is the difference between Union and the State Council of Ministers? The Council of Ministers headed by the Prime Minister is the real executive in our politico-administrative system in Union level, and Council of Ministers headed by Chief Minister and is the real executive in our political administrative system in the state level. Then at the union level, they are appointed by the president on the advice of the prime minister, and same applies to the state also, appointed by the governor on advice of the chief minister. And they form 15% of the total strength of the Lok Sabha, and here 15% of the total strength of the state legislative assembly. Then the members of the Lok Sabha and Rajya Sabha can be appointed as ministers, and members of state legislative assembly and state legislative council can be appointed as ministers. A minister ceases to exist as one if he is not a member of either house of the parliament for 6 consecutive months, and same applies to the state also. Minister can participate in the proceedings of the other house in which he or she is not a member but cannot vote. Same applies to the state also. Okay, same. The functions are almost the same. The election, appointment, everything is almost the same only. Now, the oath to bear faith and allegiance to the Constitution of India, uphold sovereignty and integrity, to faithfully and conscientiously discharge the duties of his office, and to do so right to all manner of people in accordance with the Constitution and the law, without fear or favor, affection or ill will. Same applies to the state also. The oath. Oath of secrecy. In his oath of secrecy, the minister swears that he will not directly or indirectly communicate or reveal to any person or persons any matter that is brought under his consideration or becomes known to him as a state minister, except as may be required for the due discharge of his duties as such minister. So basically, it's the oath of secrecy. Whatever comes to his office or in his direction or under his command, and it should be kept secret. Okay. So that is what is the oath of secrecy means. Now the collective responsibility. What do you mean by collective responsibility? Article 75 says that the states that the Council of Ministers is collectively responsible to the Lok Sabha. They are collectively responsible and answerable to the Lok Sabha of the lower house. And in the case of the state, Article 164 discuss about it. The Council of Ministers is collectively responsible to the state legislative assembly. All the ministers on joint responsibility to the Lok Sabha for all their acts of omission and commission. Same applies to the state also, but they are actually responsible to the state legislative assembly. Then they work as a team, swim or sing together. Same applies to state also. They work as a team. Individual responsibility. Article 75 also contains the principle of individual responsibility. Here in the state, Article 164 contains the individual responsibility aspects. It states that the ministers hold office during the pleasure of the president, and here the ministers hold office during the pleasure of the governor, and president can remove a minister even at a time when the Council of Ministers enjoys confidence of the Lok Sabha. That even applies to the state also. Governor can remove the minister. However, the president removes a minister only on the advice of the prime minister. Basically, the president is actually mainly functioning based on the aid and advice of the Council of Ministers headed by the Prime Minister. So you can see that if the president wants to remove one particular minister also, it should be on the advice of the Prime Minister, and same applies to the state in the case of the Chief Minister and the Governor. Okay, that is individual responsibility. Now there is something called as legal responsibility, but in India it is not applicable. No legal responsibility. So what do you mean by that? Legal responsibility means in Britain, every order of a king for any act is countersigned by a minister. All the acts are actually countersigned by the minister, but in India it is not the case. If the order is in violation of any law, the minister will be held responsible and will be liable in the court, not the king. It is the minister will be liable in the court. In India, there is no provision in the constitution for the system of legal responsibility of a minister. It is not required that an order of the president or governor for a public act should be countersigned by a minister. The courts are barred from inquiring into the nature of advice rendered by the ministers to the president or governor. Very important to understand this. The courts are barred from this because that is one of the function of the legislature and the executive. So the courts are not entitled to involve in that. Then ministers. What are the types of ministers? Cabinet ministers. These head the important ministries of the central government like the Home, Defense, Finance, External Affairs, and so forth. Then the cabinet is the chief policy formulating body of the central government, and ministers of state means these can either be given independent charge of ministries or departments or can be attached to a cabinet minister. Deputy ministers means they are attached to the cabinet ministers or ministers of the state and assist them in their administrative, political, and parliamentary duties. These are the types of ministers we can see in our country. Then what's the difference between the Council of Ministers and Cabinet Ministers? Council of Ministers is a wider body, 60 to 70 ministers you can see, but in the case of Cabinet, it's a smaller body, it's a decision-making body, 70 to 20, and includes Cabinet Ministers, Ministers of State, and Deputy Ministers, but here Cabinet Ministers only, and it has no collective functions, but Cabinet has collective functions, and it is vested with all powers, but in theory, the Council of Ministers, but mainly the power lies with the Cabinet only, acts on behalf of the Council of Ministers, implements decisions taken by the Cabinet, and directs the Council of Ministers. And it is a constitutional body as per Articles 74 and 75, and it was these articles were later inserted in Article 352 by 44 Amendment Act 1978. And it collectively responsible to the lower house and enforces the collective responsibility of the Council of Ministers. So basically, the cabinet is a smaller body, but it's a highly powerful decision-making body among the Council of Ministers also. Okay, so that's the difference between Council of Ministers and the cabinet. The constitutional provisions, Article 74. The advice tendered by the ministers to the president shall not be inquired into any court. The president may require the Council of Ministers to reconsider such advice, and the president shall act in accordance with the advice tendered after such reconsideration. That is Article 74. Then Article 75, the Prime Minister shall be appointed by the President and other ministers shall be appointed by the President on the advice of the Prime Minister. Okay. Now, the Council of Ministers shall not exceed 15% of the total strength of the Lok Sabha, including the Prime Minister, and 91st Amendment Act 2003 added this particular provision. 15% of the total strength of the Lok Sabha. Article 77 talks about the President shall make rules for the more convenient transaction of the business of the Government of India and for the allocation among ministers of the said business. And 78 talks about to communicate to the President all decisions of the Council of Ministers relating to the administration of the affairs of the Union and proposals for legislation. So I've already told you that these are some of the articles which actually have some connection related to the ministers and their powers. Article 88 talks about every minister shall have the right to speak and take part in the proceedings of either house, any joint sitting of the houses, and any committee of parliament which may be named a member, which he may be named a member, but he shall not be entitled to. That provision is there to be a part of these proceedings in either house or joint sitting, etc. Now, cabinet committees. Cabinet committees. These are extra constitutional in emergence. In other words, they are not mentioned in the constitution. So, cabinet committees are not mentioned in the constitution. And two types of committees you can see: ad hoc committees and the standing committee. Ad hoc committee is temporary and standing committee is permanent. Okay, and the rules of business provides for their establishment. The executive in India works under the Government of India Transaction Business Rules 1961. The Prime Minister constitutes standing committees of the cabinet and sets out the specific functions assigned to them. Okay, standing committees are actually constituted by the Prime Minister. Their membership varies from 3 to 8. They usually include only cabinet ministers. Non-cabinet ministers can also be included as members. Apart from the ministers in charge of the subjects covered, other senior ministers can also be part of the member. And then such committees are usually chaired by Prime Minister. At times, other cabinet ministers like Home, Finance, etc. can also be chairperson. But if the Prime Minister is a member of the committee, then he or she is the head of the committee. So that's about the cabinet committee, the features of the cabinet committee. Who is actually heading the cabinet committee, or what is the number of people who are involved in the committee. So this is what is mentioned here. And there are 8 cabinet committees you can see. One is Appointments Committee of the Cabinet. Then Cabinet Committee on Accommodation, Cabinet Committee on Economic Affairs, Cabinet Committee on Parliamentary Affairs, Cabinet Committee on Political Affairs, Cabinet Committee on Security, Cabinet Committee on Investment and Growth, Cabinet Committee on Employment and Skill Development. All committees except Cabinet Committee on Accommodation and Cabinet Committee on Parliamentary Affairs are headed by the Prime Minister. So all committees except this Committee on Accommodation and Cabinet Committee on Parliamentary Affairs are headed by the Prime Minister only. They are an organizational device to lessen the enormous workload of the cabinet, and they facilitate an in-depth examination of policy issues and effective coordination. And they are based on principles of the division of labor and effective delegation. And they not only resolve issues and frame proposals for the cabinet consideration, but they also take decisions. The cabinet can review their decisions. Okay, very, very important to understand about the cabinet committees also. So now we have discussed about the Prime Minister, we discussed about the Council of Ministers, right? And we discussed about the cabinet, the Union Council of Ministers, etc. Okay, so these are all very, very important to understand when you are looking at the Indian governance. And please make sure that you go through it in detail. Now we are only doing a revision. Go through it in detail, understand about it, understand each provision, because that may help you in the examination, both in prelims and. Now let us try to understand about the Supreme Court of this country. Okay, the Supreme Court was inaugurated on 28 January 1950. The Federal Court of India was created as per the Government of India Act 1935. Later it got the name the Supreme Court, and the articles 124 to 147 of Part 5 of the Constitution deal with the organization, independence, jurisdiction, powers and procedures of the Supreme Court. Article 124 to 147 of the Part 5 of the Indian Constitution. Supreme Court of India is the highest judicial court and the final court of appeal under the Constitution of India. The highest constitutional court with the power of judicial review. Supreme Court is the apex court. Okay. Article 124 of the Indian Constitution deal with the Constitution of Supreme Court of India presided over by the Chief Justice of India, CJI. Okay, so Article 124 deal with the Constitution of Supreme Court. The Constitution of India has provided for an integrated judiciary with the Supreme Court as the apex court. The Constitution of India adopted an integrated structure of judiciary from the British Constitution. The Supreme Court is the guardian of Indian Constitution and defender of the fundamental rights. Very important point. The guardian of the Indian Constitution and defender of the fundamental rights. It's a very, very important thing that we need to understand. And while understanding the nature of the judiciary itself, we have already witnessed that our judiciary is independent and integrated. Okay, what is that integration? Supreme Court, High Court, and subordinate courts. Now, how the appointment is actually conducted. The judges of the Supreme Court are appointed by the President. The CJI is appointed by the President after consultation with such judges and the Supreme Court and High Courts as he deems necessary. The other judges are appointed by the President after consultation with the CJI, Chief Justice of India, and such other judges of the Supreme Court and High Courts as he deems necessary. The consultation with the Chief Justice is obligatory in the case of appointment of a judge other than Chief Justice. The eligibility of appointment of judges of the Supreme Court of India has been prescribed under Article 124 of the Indian Constitution. So, eligibility of appointment of judges. The judge of the Supreme Court of India holds office until he attains the age of 65 years. Okay, until he attains the age of 65 years, the judge of a Supreme Court is actually holding that office. The controversy over the consultation part. Okay, there were three important cases were actually connected to this. The first judge's case in 1982, exchange of views. Then the second judge's case in 1993 regarding the concurrence, and third judge's case in 1998, consultation of plurality of judges. Okay, the sole opinion of the CJI does not constitute a consultation process. That is the point. Okay, if you are only consulting the CJI, it does not mean that it is a consultation process. He should consult a collegium of 4 senior-most judges of the Supreme Court, and even if 2 judges give an adverse opinion, he should not send the recommendation to the government. So that is the point. Then the court held that the recommendation made by the Chief Justice of India without complying with the norms and requirements of the consultation process are not binding on the government. That is also another major point. Then the collegium system was replaced by National Judicial Appointments Commission based on NJAC's Act of 99 constitutional amendment. And in 2015, the Supreme Court declared the amendment as invalid and collegium system became operative again. That is the 4th judge's case of 2015. 50. Okay, so I'm pretty sure that you might have gone through all these controversies and all these discussions related to the appointment of the judges, MJSC and the collegium system, everything you might have gone through it. So I'm just going through it a little faster. Then appointment. Besides appointment of the Chief Justice of India, the Constitution of India makes provisions for the President of India to appoint a judge of Supreme Court as an acting Chief Justice of the Supreme Court during the event of vacancy of the office of CJI, temporary absence of the CJI, and incapacity of CJI to perform official duties. So during those times, it is the responsibility of the President to appoint an acting Chief Justice. Then eligibility. The eligibility for individuals to be appointed as judges of the Supreme Court of India are listed below. One, citizen of India, mandatory. Then hold office of the judge of state high court or high courts in succession for a period of 5 years. Very important, judge of the state high court. Then served as an advocate at the state high court for a period of 10 years. Okay, so either judge as a high court or served as an advocate in a state high court, and a distinguished jurist in the opinion of the President of India. So basically, in the opinion of the President of India, that person must be a distinguished jurist. The Parliament enacts regulations and legislations to empower or constitute an authority to adjudicate on disputes over any question regarding the age. The judge of the Supreme Court submits the letter of resignation to the President of India. Very important. So he actually submits the resignation to the President of India. Then composition. The Supreme Court, the number of judges bill 2019 has added 4 judges to strength, and it increased the judicial strength from 31 to 34, including the CJI. Okay. Originally, the strength of the Supreme Court was fixed at 8, 1 Chief Justice and 7 other judges. The judges sit in benches for 2 to 3 called division or in benches of 5 or more called a constitution bench. When there are matters of fundamental questions of the law is to be decided. So, single bench is there, division bench is there, constitution bench is there. Okay. The number of judges were increased from 8 to 10 in 1956. Okay. 8 to 13 in 10 to 13 in 1960, 13 to 17 in 1777, and 17 to 25 in 86, and 25 to 30 in 2008, and 13 to 33 in 2014. Okay. 2019. Okay, it's very important to understand these dates. Not necessary that you need to by heart this information, but just have an understanding regarding the changes or the evolution of the number of judges in the Supreme Court. The courts of record. As a court of record, the Supreme Court has 2 powers. The judgments, proceedings, and acts of the Supreme Court are recorded for perpetual memory and testimony. These records are admitted to be the evidentiary value and cannot be questioned when produced before any court. They are recognized as legal precedents and legal references. It has power to punish for contempt of court, either with simple imprisonment for a term of 6 months or with a fine up to 2,000 or with both. Okay, very important. So, as a court of record, the Supreme Court has these powers. Basically, why it is actually keeping all these judgments and the proceedings as a reference, because in the upcoming cases or in the following cases that is going to happen all over the country, they can always have this as a reference. Okay, court of record. Then independence of judiciary. So what do you mean by this independence of judiciary? Basically, the exact meaning is like they are away from all kinds of pressures and they are independent to take decisions. They are free to take decisions. The Supreme Court should be free from the encroachments, pressures, or interferences of the executive, that is the Council of Ministers, and the legislature or the Parliament. The court should be allowed to do justice without fear or favor. The Constitution provisions to safeguard the independence and impartiality of the Supreme Court are as follows. 1. These are all mentioned in the Constitution so that this independence and impartiality remains the same. The salaries and allowances and the pensions of the judges of Supreme Court are charged on the consolidated fund of India. Then the mode of appointment of the judges, one thing. Security of tenure of the judges, fixed service conditions. The Parliament can extend the jurisdiction but cannot curtail the original jurisdiction and powers. Expenses charged on the consolidated fund of India. Then conduct of judges cannot be discussed. Then ban on practice after retirement. Power to punish for its contempt, and the freedom to appoint as staff, and the separation of judiciary from the executive. And all these are actually establishing the independence and impartiality of the Supreme Court or the judiciary. Oath of office. The President of India administers an oath or affirmation to any individual appointed as the judge of a Supreme Court before entering upon his office. The oath or affirmation is provided in the third schedule of the Indian Constitution. The judge has to make and subscribe to an oath affirmation before the President. So before the President, very important. In his oath, the judge of the Supreme Court swears that to bear the true faith and allegiance to the Constitution, to uphold the sovereignty and integrity of India, to duly and faithfully and the best of his ability, knowledge and judgment to perform the duties of the office without fear or favor, affection or ill will, and to uphold the Constitution and the laws. So these are the main points included in the oath of the office. Okay, for the Supreme Court judges. Very important to understand, and it is actually, taken. This oath is actually taken, or affirmation is taken before the President. Original jurisdiction. You might have heard about this term, original jurisdiction. What do you mean by that? The Supreme Court of India enjoys original and exclusive jurisdiction over certain cases. The original jurisdiction of a court is the power to hear a case for the first time. So, in such cases should be coming to the Supreme Court for the first time. Okay. Then, Article 131 of the Constitution deal with the original jurisdiction of the Supreme Court. It also means that such cases cannot be initiated in any other court. Okay, it should be first coming to the Supreme Court only, not going to any other subordinate courts or High Court. The following are the cases or disputes that come under the original jurisdiction. 1. Disputes between the Government of India on the one side and one or more states on the other side. Okay, Government of India and one or more states on the other side. You know that because High Court is dealing with a particular state only. Okay, so the High Court cannot interfere into such cases. It is only the Supreme Court can interfere. Then disputes between Government of India and one or more states on one side and one or more states on the other side. Same. Then disputes between two or more states. In all these cases, the case should first come into the Supreme Court. Only Supreme Court has the original jurisdiction over these types of cases. Article 32 of the Constitution provides original jurisdiction to the Supreme Court for matters regarding the enforcement of fundamental rights. Supreme Court can issue writs, directions, or orders, including writs in the nature of mandamus, habeas corpus, quo warranto, prohibition, and certiorari. The Supreme Court also has the power to direct a transfer of a criminal or civil case from High Court in one state to High Court in another state. Okay, one state to another, it can actually transfer the case. It can also transfer cases from one subordinate court to another state High Court. If the Supreme Court deems that the cases involving the same question of law are pending before it and one or more High Courts, and that these are significant questions of law, it can withdraw the cases before the High Courts or courts and dispose of all these cases itself. Okay, so the Supreme Court can take up the responsibility of these cases. Okay, the Arbitration and Conciliation Act 1996 gives Supreme Court the authority to initiate international commercial arbitration also. So the Arbitration and Conciliation Act 1996 provides the Supreme Court this authority to initiate international commercial arbitration. However, this jurisdiction does not extend in the following situation: the original jurisdiction. A dispute arising out of any pre-constitution treaty, so before the constitution, agreement, covenant, engagement, sanad, or other similar instrument. A dispute arising out of any treaty, agreement, etc., which specifically provides that the said jurisdiction does not extend to such a dispute. Interstate water disputes. Matters refer to the Finance Commission. Adjustment of certain expenses and pensions between the center and the states. The ordinary dispute of a commercial nature between the center and the states, a recovery of damages by a state against the center. So, in these cases, jurisdiction does not extend. Okay, this jurisdiction does not extend, which means it can be presented first in the High Courts and later it can be taken to the Supreme Court. Okay, such cases. Now, what do you mean by this public interest litigation? The pioneers of this concept of PIL or public interest litigation were Justice V.R. Krishna Iyer and Justice P.N. Bhagwati. It is a result of the Supreme Court's judicial activism. Public interest litigation is a legal action brought in a court to preserve public interests such as pollution, terrorism, traffic accidents, construction sites, hazards, etc. A public interest litigation can be brought in a court of law to address any issue where the general public's interests are at stake. So if the general public's interests are at stake, definitely you can actually initiate a public interest litigation. The ability granted to the public by courts through judicial activism known as the public interest litigation. And cases may be started on the petition of any public spirited person, or the court may take cognizance of the issue itself and proceed suo motu. Very, very important. So the cases may be started on the petition of any public spirited person, or the court may take cognizance of the issue itself and proceed suo. Okay, very, very. Suo motu means they can take its case by their own. They don't need a petition, so they can take its case by their own. According to Supreme Court, the PIL is the legal action initiated in a court of law for the enforcement of public interest or general interest in which the public or a class of community have pecuniary interest or some interest of which their legal rights or liabilities are affected. So if the public is affected by any issues or any problems which need to be taken care of, which need to be addressed immediately, then you can actually go on with the public interest litigation. So this is more about it. So the real purpose of the PIL is vindication of the rule of law, then facilitating effective access to justice to the socially and economically weaker sections of the society, meaningful realization of the fundamental rights. So these are certain advantages or the real purpose of the PIL, public interest litigation. You need to understand about it. Read more about it, okay, because you have to have more clarity regarding this. PIL ensures legal aid and is intended to bring justice within the reach of the poor masses. So legal aid and also bring justice. Tenure. The Constitution has not fixed the tenure of the judge of a Supreme Court. The provisions related with the tenure are: he holds office until he attains the age of 65, and any question regarding his age is to be determined by such authority and in such manner as provided by the Parliament. He can resign his office by writing to the President, and he can be removed from his office by the President on the recommendation of the Parliament. Okay, very, very important. So he can be removed and he can also resign. Removal of judge. The President removed the judge of the Supreme Court from office upon adoption of a resolution by both houses of the Parliament on a special majority in the same session on grounds of proven misbehavior. Very important. Proven misbehavior or incapacity. So what is a special majority? A majority of the total membership of the House and a majority of not less than 2/3 of the members at that House present and voting. So one is the total membership of the House, that is a majority, and the second one is the two-thirds of the members of that House present and voting. So maybe that day somebody may be absent. So whoever is actually present, if that is the 2/3, then definitely it can be considered as a special majority. The Justice Inquiry Act 1968 regulates the procedure relating to removal of the judge of the Supreme Court by process of impeachment. So where is it mentioned? Justice Inquiry Act 1968. No judge of the Supreme Court has been impeached so far. Okay. So far, no Supreme Court judges have been impeached. Parliament procedure. A notice has to be served before the Speaker, Chairman, signed by not less than 100 members in Lok Sabha and 50 members in Rajya Sabha. So regarding the removal of the judge, the Speaker or the Chairman may admit the motion or refuse to admit it. If it is admitted, the Speaker or Chairman is to constitute a committee, including Chief Justice, Judge of the Supreme Court, Chief Justice of the State High Court, and a distinguished jurist to investigate into the charges. The House can take up the matter for discussions based on findings of the committee. After the motion is passed by each House of the Parliament by special majority, an address is presented to the President for removal of the judge. Okay, so if it is passed in both the Houses of the Parliament by a special majority, then it will be like considered like the President is removed. The President passes an order removing the judge. So this is what the removal of the judge in the Supreme Court. High Court. High Court operates below the Supreme Court and above the subordinate courts. Occupies a higher position in a particular state. And history of High Court in India, 1862 with the establishment of Bombay, Calcutta and Madras High Court. So that's the history started. And 1866 you could see that Allahabad High Court was established. 1950 High Court of a province become the High Court of the state. The Parliament to establish a common high court for two or more states and for two or more states and union territories. It is actually based on the 7th Amendment. Delhi has a separate high court among union territories, and Jammu and Kashmir and Ladakh has a common high court. Article 214 of the Indian Constitution deals with the constitution of a state high court for each state. The state high courts have been designated to be the court of record under Article 215 of the Indian Constitution. State high court are actually designated to be the court of record under Article 215. Very important. Okay. State high courts. The judges of the high court are appointed by the president. Okay. President appoints the judges. The Chief Justice of the High Court is appointed by the President after consultation with the CJI and the Governor of the concerned state. Okay, very important. The Chief Justice of the High Court is appointed by appointed by the President after the consultation with Chief Justice of India and the Governor of the concerned state. The other judges are appointed by the President after consultation with the CJ of the concerned state, Chief Justice of the concerned state. In case of common High Court for two or more states, the Governor of all the states are consulted. In the third judge's case, 1998, the appointment of the High Court judges, the CJI should consult a collegium of two senior-most judges of the Supreme Court. Okay, so in the third judge's case, that was one of the demand or one of the judgment that the CJI has to consult collegium of two senior-most judges of the Supreme Court. Eligibility. Citizen of India, hold judicial office in the territory of India for 10 years, served as an advocate of a state high court for a period of 10 years. No provision for a distinguished jurist in the case of high court judge. But in the Supreme Court judge, you have seen that there is a separate provision for distinguished jurist in the eyes of the president. The Constitution has not prescribed a minimum age for the appointment of the judge of a high court. No minimum age for the appointment of a judge of a high court. Composition, the president decides the strength of the high court based on the workload. The Constitution does not specify the strength, and every high court consists of a chief justice and such other judges as specified by the president from time to time. Okay, very important. So it is the president who is actually deciding the number of the judges. Independence of judiciary, almost the same as the Supreme Court also. The High Court should be free from encroachments, pressures, and interference of the Executive, Council of Ministers, and Legislature. The Parliament, the court should be allowed to do justice without fear or favor. And these are some of the important, features which safeguard the independence and impartiality of the Supreme Court. One, salaries, allowances are actually charged on the Consolidated Fund of India. Then mode of appointment of the judges, security of tenure of the judges, fixed service conditions. The Parliament and the state legislature cannot curtail the jurisdiction of the High Court. Expenses charged on the Consolidated Fund of India. The conduct of judges cannot be discussed. Ban on practice after retirement. Power to punish for its contempt. Then freedom to appoint its staff and separation of judiciary from the executive. All these actually, establishes that independence of judiciary. Then what is this original jurisdiction? So this original jurisdiction means the cases will be coming first to this court. In such of cases, the applicant can directly go to the High Court and does not require to raise an appeal. The High Courts have been given original jurisdiction over cases arising out of the Parliament or state legislature elections. Enforcement of the fundamental rights also in cases of other legal rights, the matters of admiralty and contempt of court cases, the full powers to make rules to regulate their business in relation to the administration of justice, cases ordered to be transferred from a subordinate court involving the interpretation of the Constitution to its own file, very important, cases ordered to be transferred from a subordinate court involving the interpretation of the Constitution to its own file. Then the four high courts have civil original jurisdiction in cases of higher value, that is Calcutta, Bombay, Madras, and Delhi High Court. These four high courts have original jurisdiction in cases of higher value: Calcutta, Bombay, Madras, and Delhi. Writ jurisdiction. So what do you mean by writ jurisdiction? Article 226 of the Constitution empowers a high court to issue writs. So writs, we have already seen that based on Article 32, that is habeas corpus, mandamus, certiorari, quo warranto, and prohibition. Article 226 of the Constitution empowers a High Court to issue writs, namely the habeas corpus, mandamus, certiorari, prohibition, and quo warranto, for the enforcement of the fundamental rights of the citizens and for any other purposes. Any other purpose, enforcement of ordinary legal right. Writ jurisdiction of the High Court is wider than the jurisdiction of the Supreme Court. Very important. So, you need to understand that the jurisdiction or the power is actually more in terms of the Supreme Court. The High Court has more powers. Concurrent with writ jurisdiction of the Supreme Court, Article 32. Then the writ jurisdiction of the High Court and Supreme Court is a part of the basic structure. So, when you are actually taking the basic structure of India, the writ jurisdiction of both these courts, High Court and Supreme Court, is actually involved in that. Appellate jurisdiction. So, what do you mean by appellate jurisdiction? This is for cases where people have raised a complaint about the review of a judgment given by the district level or subordinate court of the territory. The appellate jurisdiction of High Court extends to both civil and criminal cases. So, in civil cases, the jurisdiction extends to cases tried by courts of municipal and the district judges. In the criminal cases, it exceeds to cases deciding by sessions and additional sessions judges. The High Court can hear appeals against the decisions of the lower courts in most of the revenue cases also. Okay. Any case involving the interpretation of the Constitution or law is brought to the High Court in appeal. Appeal in cases of income tax, sales tax, etc. can be heard by the High Court. Appeal in the cases of income tax, sales tax, etc. can be heard by the High Court. So these are all appeal. Regarding the appeal, if you are not satisfied with the judgment or the verdict of the lower court, then definitely you can go on an appeal. So that is what is mentioned here. Then supervisory jurisdiction. The power of superintendence over all courts and tribunals functioning in its territorial jurisdiction, except military court and tribunals. Okay, they have the power to superintend the other courts functioning under its territorial jurisdiction. It covers administrative and judicial superintendence. It is a revisional jurisdiction and it has a suo motu on its own, not necessarily on the application of a party. The governor also concerns the High Court in the appointment and transfer of judges and other officers of the judicial services in the state. So very, very important to understand these points. So suo motu or it is basically based on the supervisory jurisdiction of the High Court. Okay. Control over subordinate courts. This is an addition to the supervisory and appellate jurisdiction. It states that the High Court can withdraw a case pending before any subordinate court if it involves a substantial question of law. Very important. If it involves a substantial question of law, definitely they can involve. The case can be disposed of itself or solve the question of law and return back to the same court. The governor also consults the High Court in the appointment and transfer of district judges and other officers of the judicial service in the state. Deals with matters of posting, promotion, grant of leave, transfers and discipline of the members of the judicial service of the state. Okay. Deals with matters of posting, promotion, grant of leave, transfers and discipline of the members of judicial service in the state. So these are all controls or functions over the subordinate courts in the country. Court of record, very important. It involves recording the judgments proceeding to and acts of high courts for perpetual memory and testimony. These records cannot be further questioned in any court. They are considered as legal precedents and legal references. Yes, it has the power to punish for contempt of court itself with either simple imprisonment or with a fine or with the very important. So, same like the Supreme Court. Regarding the contempt of court, Act 1971 defines both civil and criminal contempt. Civil contempt refers to willful disobedience of any judgment of the court. Criminal contempt can be invoked if an act tends to scandalize or lower the authority of the court, tends to interfere with the due course of any judicial proceeding, and obstruct the administration of justice. So, if these three, characters are there, then it can be considered as a criminal contempt. But if they are willfully disobeying the judgment of the court, then it is considered as a civil contempt. Okay. Now coming to the judicial review, very important. And it is a power exerted by the courts of a country to examine the actions of the legislature, executive and administrative arms of government, and to ensure that such actions conform to the provisions of the nation's constitution. Very important. So basically, to examine the administrative arms of the government and also the legislature, because they need to ensure that such action conform the provision of the nation's constitution. Okay. Then it is a type of court proceeding in which the judge reviews the lawfulness of a decision or action made by the public body. In other words, we can say that their activities are in line with the constitution of this country. Then Article 13 and 226 of the Constitution explicitly mention about the judicial review. Article 13 and 226. The state high courts enjoys the power of judicial review for the purpose of examining the constitutionality of legislative enactments and executive orders of the government, both at the levels of state and center, on the following three grounds: in infringement upon fundamental rights, competence of authority, ultra vires provisions to constitution. So in these three circumstances, you can see that the power of judicial review is exercised. The tenure of the judges, the constitution has not fixed the tenure of the judge of a high court. Okay, so he holds office until he attains the age of 62, and he can, any question regarding the age, his age is to be determined by the president after consulting with the CJI, and the president's decision is final. He can resign his office by writing to the president, and he can be removed from his office by the president on the recommendation of the parliament, and he vacates his office when he is appointed as the judge of a Supreme Court or when he is transferred to another high court. Okay, so that's about the tenure. Removal of judges, like we have already seen that the president can remove a judge of a high court from office upon adoption of a resolution by both houses of the parliament on a special majority in the same session on grounds of proven misbehavior or incapacity. So mainly the points are proven misbehavior or incapacity. Special majority means the majority of the total membership of that house and the majority of not less than 2/3 of the members of that house present. And the Judges Enquiry Act 1968 regulates the procedure relating to the removal of the judge of the Supreme Court by the process of impeachment. No judge of the Supreme Court has been impeached so far. Okay, so Judges Enquiry Act 1968. The Parliament procedure for the removal part. A notice has to be served before the Speaker or Chairman, signed by not less than 100 members in Lok Sabha and 50 members in Rajya Sabha. The Speaker or Chairman may admit the motion or refuse to admit it. If it is admitted, the Speaker or Chairman is to constitute a committee, and committee should be consisting of Chief Justice or a judge of the Supreme Court, then Chief Justice of the High Court, and a distinguished jurist. The House can take up the matter for discussions based on the findings of the committee. After the motion is passed by each House of Parliament by special majority, an address is presented to the President for removal of the. Very important. After the motion is passed by each House of the Parliament by special majority, an address is presented to the President for removal of the judge. The President passes an order removing the. So this happens with the case of the Parliament procedure related to the removal of a judge. The transfer of judges. The President can transfer a judge from one High Court to another. The third Judges Case 1998 says that in the transfer of High Court judges, the CJI should consult 4 senior-most judges of the Supreme Court and CJI of 2 states. That is the Chief Justice of 2 states. The one from which the judge is transferred and the one that receives the judge. Okay, so when the transfer is happening from one place to another, that particular activity should be conducted or should be done after consulting the Chief Justice of the both these states. Okay, state high courts. The sole opinion of the CJI does not constitute a consultation process. So if CJI is simply taking decision by alone, then that is not considered as a consultation process. The next important topic is subordinate courts. Article 233 to Article 237 in the Part 6 of the Constitution make the following provisions to regulate the organization of subordinate courts and to ensure their independence from the executive. So Article 233 to Article 237. Appointment, posting and promotion of the district judges are made by the governor of the state in consultation with the High Court. Okay, so it is actually made by the governor of the state. The appointment of other judges are made by the governor after consultation with the State Public Service Commission and the High Court. Okay. Control over subordinate court is vested with the concerned state high court. The control over subordinate courts is actually vested with the concerned state high courts. You know about it because that is the integrated structure of our judiciary. Then qualification of district judges. He should not already be in the service of the central or the state government. He should have been an advocate or a pleader for 7 years, and he should be recommended by the High Court for appointment. So these are the qualifications. Now the structure and jurisdiction. In each district of India, there are various types of subordinate or lower courts. They are civil courts, criminal courts, and revenue courts. Civil, criminal, and revenue courts. The organization, jurisdiction, and nomenclature of the subordinate judiciary is laid down by the states, and there are 3 tiers of civil and criminal courts below the High Court. Okay, 3 tiers. So, regarding the criminal court, that is Sessions Judge Court, district level, Chief Judicial Magistrate Court, and the Judicial Magistrate Court. Regarding the civil court, that is District Judge Court, then Subordinate Judge Court, and the Municipal Court. So these are the 3 divisions or 3 tiers you can actually see in the civil and criminal courts. The district judge exercises both administrative and judicial powers. In metropolitan city civil courts on the civil side and court of metropolitan magistrates on the criminal side. Okay, so metropolitan cities, city civil courts on the civil side and court of metropolitan magistrates on the criminal side. In some states, panchayat courts try petty civil and criminal cases through Nyaya Panchayat, Adalati Panchayat, Gram Kacheri, Panchayat Adalat, etc. Okay, so this is how our judiciary works or our justice system works in the country, in the subordinate level. Then Sessions Judge. The district judge is the district's highest judicial authority with original and appellate authority in both civil and criminal issues. He or she is known as the district judge when dealing with civil issues and the sessions judge when dealing with the criminal. So it is very important to understand that he or she is known as district judge when they are dealing with civil issues and sessions judge when they are dealing with criminal issues. The sessions judge has the power to impose any sentence, including life imprisonment and capital punishment. However, capital punishment passed by him is subject to confirmation by the High Court whether there is an appeal or not. Okay, very important points. Now, National Legal Services Authority, NLSA. National Legal Services Authority provides free legal aid and advance, spreads legal awareness and promotes settlement of disputes through ADR mechanisms. What is the mission of this National Legal Services Authority? To legally empower marginalized and excluded groups of the society by providing effective legal representation, legal literacy, awareness, and bridging the gap between the legally available benefits and the entitled beneficiaries. So, very important to understand this. It is to bridge the gap. Okay, bridge the gap between the legally available benefits and the entitled beneficiaries. To strengthen the system of lok adalats and other alternate dispute resolution mechanisms in order to provide for informal, quick, inexpensive and effective resolution of disputes and minimize the load of adjudication on the overburdened judiciary. So basically to reduce the load of the judiciary, because there are a lot of pending cases in the judiciary. So in order to reduce that, we are having the NLSA and it is one of the mission of that. Okay, NLSA. Witness and all pleadings, memo of appeal, paper book, documents in legal proceedings, then drafting of legal documents, special leave petition, etc., and supply of certified copies of judgments, orders, notes of evidence, and other documents in legal proceedings. So these are the free legal aid. Okay, which is actually these are the supports given by National Legal Services Authority. Okay, so representing through an advocate or the payment of process fees, etc., and preparation of pleadings, memo of appeal, etc., drafting of legal documents and also supply of certified copies of judgment. So these are all the services offered by the NLSA. Who is eligible for the services of NLSA? Women and children, members of scheduled caste or scheduled tribes, industrial workmen, persons with disability, persons in custody, victims of human trafficking, victims of natural disasters, ethnic caste violence, industrial disaster, and person with an annual income of less than 1 lakh or as notified by the central or state government. Okay, so these are the people who are eligible to get the services of National Legal Services Authority. Now, what is Lok Adalat? Lok Adalat means people's court. Lok Adalat means people's court. Lok Adalat is the one of the alternate dispute redressal mechanism, ADR mechanism, and it is a forum where disputes cases pending in the court of law or at pre-litigation stage are settled, compromised amicably. So basically, to reduce the burden of the judiciary, Lok Adalats have been given statutory status under the Legal Services Authorities Act 1987. So very important to understand this. Under the said act, the award or the decision made by the Lok Adalats is deemed to be a decree of civil court and is final and is binding on all parties. No appeal against such an award lies before any court of. Very important. So it is actually having the power and authority as like a civil court. And if the parties are not satisfied with the award of the Lok Adalat, though there is no provision for an appeal against such an award, but they are free to initiate litigation by approaching the court of appropriate jurisdiction by filing a case by following the required procedure in exercise of their right to litigate. Okay, so that's the power of Lok Adalat. So you need to understand about Lok Adalat. There is no court fee payable when a matter is filed in the Lok Adalat. No court fee. If a matter pending in the court of law is referred to the Lok Adalat and is settled subsequently, the court fee originally paid in the court on the complaints petition is also refunded back to the parties. The first Lok Adalat camp was organized in Gujarat in 1982 as a voluntary conciliatory agency without any statutory backing for its decisions. As per the Supreme Court, it is an old form of adjudicating system prevalent in ancient India and its validity has not been taken away even in the modern days too. The State District Legal Services Authority or the Supreme Court or High Court Taluks Legal Services Committee may organize Lok Adalats at such intervals and places and for exercising such jurisdiction and for such areas as it thinks fit. Every Lok Adalat organized for an area shall consist of such number of serving or retired judicial officers and other persons of the area as may be specified by the agency organized. Basically, what's the way in which the Lok Adalats are actually conducted and who can actually conduct the Lok Adalat? All those things are mentioned here. And it was first organized in Gujarat in the year 1982. Now you need to understand about the levels and composition of the Lok Adalat. You can pause for a moment and you can understand about it. And at the state authority level and also the high court level, you can see the composition and levels of the Lok Adalat. Please pause for a moment and you can read about it. Then at the district level and at the taluk levels. In all these levels, you can see the composition of Lok Adalat. So please go through it. Just pause for a moment and read about it and understand. So these are some of the important aspects related to the judiciary in our country. So we have mentioned about Supreme Court, we have mentioned about High Court, we have mentioned about the subordinate courts, and we also have seen details about the National Legal Services Authority and Lok Adalats.